to let you know where we're going to be going the next few times we meet. I know it's sometimes hard shifting gears between material science, medicine, and law. But to give you an idea where we're going, today and tomorrow, still no heavy lifting for you folks. Still, kind of sit back and enjoy the ride sort of days. Today we're going to be talking about the fascinating history of patents, copyrights, and trademarks. We've already covered the origins of intellectual property as a general subject matter. So today we'll get into the history of patents, trademarks, and copyrights. And tomorrow we'll get into some of the technical differences between the three. I want you to bear with me because this history, I think, is very important for understanding some of the technical stuff that we're going to be doing starting next week. After we get through the historical origins of patents, copyrights, and trademarks and talk about some of the technical differences between the three, we're going to get into patents, copyrights, and trademarks and devote some serious time to a technical understanding of how to obtain a modern patent, trademark, and copyright. We're going to prepare our own application for a patent. We're going to have a device to examine and describe. And so this historical background really is the bedrock, the basis, the foundation of everything that you're going to need to learn and apply later on when dealing with modern patent, copyright, and trademark law. So with that, let's delve into our not so heavy lifting day by talking about the fascinating history, at least as I call it, of patents, trademark, and copyrights. Has anybody heard of the United States Patent and Trademark Office? Okay, some hands sort of go up, some heads nodding. I mean, that's something most people have heard about. Obviously, as the name implies, it's the organization, the governmental organization of this country, which actually issues patents and trademarks. The United States Patent and Trademark Office is an agency of the United States Department of Commerce. It grants patents to inventors for their devices and innovative processes, and copyright and trademark protection for intellectual property identification. The USPTO's mission, as it states, is to maintain a permanent interdisciplinary historical record of all U.S. patent applications in order to fulfill objectives outlined in the United States Constitution. The United States Constitution, what does that have to do with patents, copyrights, and trademarks? The legal basis for all patents and copyrights comes from Article 1, Section 8 of the United States Constitution. And Article 1, Section 8 is that part of the United States Constitution where the powers of Congress are defined. Now you notice I didn't say that Article 1, Section 8 covers trademarks as well. That's a slightly different topic, and we're going to explain the differences between these clauses in the United States Constitution because they're important. But in terms of the origins of the law in the United States with respect to patents, trademarks, and copyright, it all starts with the United States Constitution. And it all starts with Article 1, Section 8 of the Constitution. It's interesting, I think, one of the things I had to do in making this course, trying to make this course and this subject matter relevant for material science students is I had to kind of go back and teach myself where all of these laws that I learned about, these concepts I learned about in law school came from. And I started thinking about the guys, and I mean that, I mean no gender bias when I say it, but it was a bunch of guys that sat down that wrote the United States Constitution. And I started thinking about these folks. And one of them, of course, was Benjamin Franklin, one of the original drafters of the United States Constitution. And he just happened to be one of this country's, and in fact the world's most prolific inventors at that time. He invented was famous for inventing bifocals, and of course the lightning rod. Can anybody think of anything else that Ben Franklin is famous for inventing? Might be something worth looking up. He was also one of the first open source inventors, but he refused to take out patents, even though they were available to him back when he was inventing the bifocal or the lightning rod or some of the other things. And I thought it was very interesting, something that he wrote once. He said, that as we enjoy great advantages from the invention of others, we should be glad of an opportunity to serve others by any invention of ours. And this we should do freely and generously. Wow. Can you imagine if General Motors or Ford or Tesla or any of the companies actually applied or took to heart Ben Franklin's words? But those words, I think, point out one of the phrases used in the United States Constitution. And we'll get into it, but Ben Franklin is a very interesting guy, and one of the people who is responsible for the drafting of Article 1 of the United States Constitution. And that's his perspective. This is the mindset that he brought to that task. Another one of the writers of the Constitution, Thomas Jefferson, another prolific inventor. And one of the coolest things about Monticello, if you've ever been there, is the ability to observe all of the little gadgets and inventions and refinements that Jefferson put together in order to make his life easier. Rocking chairs and all kinds of devices that he was an inventor of. But beyond his little gadgets, like the swivel chair or his refinements of the polygraph, he also worked on agricultural implements and developed one of the first secure methods of mechanical encryption, code writing. George Washington, we think of him as, the guy going across the Delaware with the square jaw and the wooden teeth, but he was also another prolific inventor. In his case, he was a farmer. Anyhow, here's the clause that we're talking about. Article 1, Section 8 of the United States Constitution states that Congress shall have power to provide for general welfare of the United States and to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Right there in the Constitution, they thought so much of the importance of intellectual property rights that the founders, Benjamin Franklin, James Madison, Thomas Jefferson, and the other writers of the Constitution put it right into that document. They're planning to create a nation. And one of the things that they secured to the citizens of this country, and one of the powers that they granted to Congress, was the right to secure intellectual property rights. This clause, known also as the Patent and Copyright Clause, is the foundation upon which the national patent and copyright laws rest. Although, of course, neither the term copyright or patent is actually used in the United States Constitution. So far as patents are concerned, modern legislation dates back to the British Statute of Monopolies, back in 1624, where Parliament gave inventors the sole right to their inventions for 14 years. There is some evidence, actually, that the ancient Greeks issued patents. In England, grants in the form of letters patent were issued to the king, by the king, to inventors who petitioned and were approved. These letters patent provided the recipient with a monopoly and By that I mean an absolute monopoly to produce particular goods or provide particular services for a specified period of time. And usually the extent of the monopoly and the length of the time in which those intellectual property rights were conferred to the applicant depended upon how much money you gave to the king. The first Italian patent was awarded by the Republic of Florence in 1421. The Florentine architect Filippo Brunelleschi received a 3-year patent for a barge with hoisting gear that carried marble up the sides of buildings along the Arno River in 1421. So patent rights and the origins of patent right go back to obviously the 15th century and before that. Patents were systematically granted in Venice. Venice, which was famous for glass making back in the 1400s, had a system of granting patents where they, once again, the king issued a decree by which new inventions and devices had to be communicated to the Republic in order to obtain legal protection against potential infringers. And the period that a patent lasted back in ancient Venice was 10 years. As I said, they were famous for their glass making, so the Venetian Patent Statute, issued by the Senate of Venice in 1474, was one of the earliest patent systems in the world. And as Venetians emigrated, they brought their laws to, first of all, the rest of Italy. At that time, it was essentially a set of nation states, loosely joined together. And as Venetians moved throughout Italy and then moved throughout Europe, they brought their system of patent law with them. And one of the things you'll notice is, even in these very, very early renditions of patent law, the rights are starting to be identified. There's a term, they last only a certain period of time. And they try to define the type of rights that are granted. So even 500 years ago, they were actually talking about very modern concepts that we still deal with today in terms of defining the limits of the intellectual property right being conveyed and defining even the terms, how long these intellectual property rights should last. And that's because there's a constant tension between how long someone should maintain an intellectual property right and exclusive rights to it, and society's right to share in that and advance. Remember, it's the advancement of science, which is one of the important parts of intellectual property rights that Franklin was talking about, in which Article 1, Section 8 of the United States Constitution pays homage to. I thought you might actually take a look at the Venetian Patent Statute of 1474. Here it is, courtesy of Google Images. A copy of the Venetian patent of 1474. Unless your Italian is better than mine, I have no idea what it says. But that's a copy of the document. Moving forward into the 15th century, 16th century, King Henry of France introduced the concept of publishing the description of an invention in a patent in 1555. Patents were granted by the monarch and other institutions with loyal and scientific connections, like the Maison du Roux and the Parliament of Paris. Digests were published irregularly starting in 1729. But the first publication of patents you can find back in Paris, back in France, back in the early 18th century. Examinations were generally done in secret with no requirement to publish a description of the invention, and the use of the invention was deemed inadequate adequate disclosure to the public. So that was the state of patent law back in the early 1700s. Obviously, we couldn't deal with a system like that today, not in a modern commercial environment such as we have here. But these are the early origins of patent law. moving on, the English patent system evolved from its medieval origins into the first modern patent system that recognized intellectual property rights in order to stimulate invention. This was the crucial legal foundation upon which the Industrial Revolution could emerge and flourish. By the 16th century, the king would habitually grant letters patent for monopolies to favored persons, or persons who were prepared to pay for them. So if you were related to the royal family, you would get patents. If you had a lot of money to donate to the royal family, and it was actually at the time a very significant source of income for the monarchy. It's how they built a lot of the palaces that they created during this period of time. It was on the royalties, hence the term, that they obtained from granting patent licenses. Blackstone explained how letters patent were so called because the seal hung from the foot of the document. They were addressed to all to whom these presents shall come, and could be read without breaking the seal, as opposed to letters closed, addressed to a particular person who had to break the seal to open them. The English Statute of Monopolies, passed by Parliament, restricted the Crown's power to explicitly, so that the king could only issue letters patent to inventors or introducers of original inventions for a fixed number of years. The practice of issuing patents kind of got out of hand, and so that anybody with a sum of money or property to donate to the king, or anyone who happened to be related to the king, could get a patent. And it became actually an inhibition to commerce at the time. It actually became a very corrupt system. And once Parliament began to wrest power from the monarchy, one of the first things that it did was pass this law that restricted the king's right to issue patents. Parliament, as the representative of the people, was concerned with commerce much more than the king was. The king was kind of interested in building palaces. So Parliament, in the same way that our Congress regulates commerce, began to take power, seize power with respect to inventions and intellectual property. So it voided all existing monopolies and dispensations granted by the king, with the exception of the sole working or making of any manner of new manufacturers within this realm to the true and first inventor and inventors of such manufacturers, which others at the time of making such letters patent and grants shall not use. So by this, what they were really doing is trying to put the system that had got out of hand back on the tracks. And you can see echoes of modern patent law in this very phrase. I mean, does anybody recognize one of the things that has been adopted, in fact, wasn't adopted in the United States until March of 2013? What's the
First to invent.
Yeah, first to invent. Has anybody heard first to file, first to invent? These are concepts that really were concerning us all the way back in the 1600s. And this statute, as it says here, became the foundation for later developments in patent law in England and here in the United States. In the 13 colonies, inventors could obtain patents through a petition to a given colony's legislature, which in the 1600s was called the General Court in Massachusetts. In 1641, and again, I'm trying to make this relevant to material science students, but it just happens, I didn't go back in history and make this happen, but it just so happens that the first patent ever issued here in North America had to do with material science. And it was given in 1641 to Samuel Winslow, who was granted the first patent in North America by the Massachusetts legislature for a new process for making salt. Towards the end of the 18th century, the granting of patents began to be viewed as a form of intellectual property right, rather than simply an economic privilege. The first evidence of the abuse of patent law actually happened at this time as well. Yes?
Is there any protection, I guess, I'm wondering, in the system for someone that, like, has a patent but doesn't have any desire to, like, fully work with his design? He more does it for, like, the monetary gain, and then doesn't really want the manufacturing side of it, just thinks of the idea, and then wants our to pay him from there.
Well,
Part of the process.
if I understand your question, the answer is, I'll answer it this way. An intellectual property right, like a patent, a copyright, or a trademark, let's use the example of a patent. And let's say I was able to patent the design for this chair. If I, as the owner of that patent, as the owner of that intellectual property right, I could do anything I want with it. Like Benjamin Franklin, I could give it away, or like Tesla, or Toyota, or Zuckerman at Facebook. I could give that intellectual property right away. Or I could avail myself of the rights that a patent holder has, and I can license it. I can do anything I want with it. It's like owning a computer. Once it's yours, you can do whatever you want. I can give this computer away to somebody, or I can use the rights that the law gives me to license it, to rent it out to people, to use it in any way that is consistent with a property right. So it's the same as owning a car or a house. An intellectual property right is a tangible interest in an idea that is manifest.
Okay, you don't see that as like living in a society of knowledge that the person isn't working on it?
Well, yeah, I do. And so do the folks that did that regression analysis at Sloan. I think it's patently true, to coin a phrase, that the creation of monopolies on systems and ideas does sometimes inhibit the advancement of science. Maybe are in more agreement with Benjamin Franklin on this than most people, and that's the tension that we have as a society. In order to promote science, we have to give people an incentive to develop new processes and methods and inventions. And the way to give them that incentive, since Whole Foods doesn't hand out groceries because you're a nice person, we create economic incentives for them. At the same time, so those economic incentives create certain monopolies. They create vertical and horizontal monopolies with respect to the information and the markets that device can be sold to. But at the same time, sometimes science loses out, and the advancement of science is inhibited. And that's what we saw with Tesla, and that's what we saw with Toyota. At some point, that intellectual property right, which they up until that time had very, very rigorously guarded, was actually acting against their best interests, their commercial interests. So they decided to release that information. So there's this tension that is constantly being played out in intellectual property law. And it's why Congress and the courts sometimes have to make very difficult decisions when it comes to the enforcement of these rights, or the promotion of these rights, or in some cases the limitation of these rights. That's one of the reasons why back when Parliament and when the Venetians were deciding what to do about patent law, they put restrictions on them of 10 years. What's the right restriction? 10 years? Or 5 years? Or is it 20 or 12 years? It has changed over history. And so in different systems, whether it happens to be in England or in France or in Germany or here in the United States or the Venetians back in the 1400s, they've all had to wrestle with this same question, the very question that you put your finger on, which is what is the proper balance to strike between the rights of protecting the rights of intellectual property owners and promoting society's general welfare. It's a balance that is not perfect and is constantly seeking different states of equilibrium. but it really is at the heart. And you put your finger on what is probably the most important concept when it comes to understanding modern patent, trademark, and copyright law. It's this balancing test. What's the rights of society versus the property rights of the inventor? What sort of monopoly should we grant them? What sort of commercial rights do they have? And at whose expense? And that's the question that we're still wrestling with, and which the Constitution says Congress has to deal with. And that's the $64,000 question. The Patent and Copyright Clause of the United States Constitution was proposed in 1787 by James Madison and Charles Pinckney in the Federalist Papers. So you can actually go back, drill down, open up the Federalist Papers. I think it's Federalist Paper 473, and you can read what Madison said about this. The utility of the clause, meaning the Patent and Copyright Clause, Article 1, Section 8, the utility of the clause will scarcely be questioned. The copyright of authors has been solemnly adjudged in Great Britain to be a right of common law. The right to useful invention seems with equal reason to belong to the inventors. The public good fully coincides in both cases with the claims of the individuals. Here's James Madison talking about exactly what you're talking about. James Madison, who is the Federalist Papers were the papers that were distributed amongst the colonies and the legislatures back at that time concerning the draft of the Constitution. This is basically the background document that the United States Constitution was based on. These are the ideas, the legislative intent, if you will, of the framers. And here Madison is talking about how this property right has already been well recognized in societies that they respected and wanted to emulate. And here he's talking about this tension between the rights of intellectual property holders and society in general. We're creating a new society here. These are the things that we need to be concerned about. And so you can actually drill down in the Federalist Papers and see what the framers actually wrote about when it came to the adoption of this clause. The first Patent Act of the United States Congress was passed in 1790, which is 1 year after the adoption of the United States Constitution. And it was titled An Act to Promote the Progress of Useful Arts. And the first U.S. patent was granted on July 31st, 1790 to Samuel Hopkins for a method of producing potash. Again, material scientists all the way back to 1790 are at the heart of the creation of intellectual property rights. And I thought you might like to have a look at the first patent. This is Samuel Hopkins's 1790 patent. They look a little different, as we're going to find out next week, but there it is, the first patent ever granted by the United States Patent and Trademark Office pursuant to the congressional power it was given. Again, thank you to Google Images. All right. The earliest law required that a working model of each invention be submitted with the application. Of course, they no longer require that. Patent applications were examined to determine if the inventor was entitled to a grant of the patent. The requirement for a working model was eventually dropped. In 1793, the law was revised so that patents were granted automatically upon submission of the description. And a separate patent office was created in 1802. So back in 1790, what the precursor of the United States Patent and Trademark Office was looking for is, first of all, were you looking for evidence that you were the originator of the patent? Is it yours, or did you steal it? And number two, what is the utility? Does this in some way offer utility or usefulness? Is this a unique process or thing that is worthy of a patent? And those were the only two things that you had to show. But even today, in 2015, that's essentially what the U.S. Patent and Trademark Office is concerned about. Are you the inventor of the process or the device, and does it have a utility? I thought you'd like to see one of their first patents, the Autocannon by James Puckle. This is one of the first inventions that was described, if you will. You didn't have to, as I said, usually you'd have to bring the invention into the U.S. Patent and Trademark Office or its precursor and demonstrate your invention that way. Eventually, when they did away with that requirement and required inventors to simply provide descriptions of the device, this was one of the first descriptions ever provided, and of course had to do with a weapon of mass destruction. But that's, I guess that's the way history always has been. But that's an early patent. You can go to the United States Patent and Trademark Office and you can actually look it up. Copyright. So copyright law traces its origins back to the English Statute of 1710, which secured to authors of books the sole right of publishing for designated periods of time. The history of copyright law starts with early privileges and monopoly granted to the printers of books by something called the Statute of Anne in 1710. The Statute of Anne was actually called an act for the encouragement of learning by vesting copies of printed books in the authors or purchasers of such copies during the times therein mentioned. I think you know why they call it the Statute of Anne for short. But whoever wrote that must have belonged to the school of calling things what they actually are. But that's the earliest, I think, recognition of the intellectual property right known ultimately as modern copyright. Over time, such uses such as translations and derivative works were made subject to copyright. By the way, copyright simply literally means, if you look up the word, it means to copy. Okay? And what they were concerned about very early on was the copying of books and manuscripts, particularly when the printing press was invented. The first books and manuscripts, of course, were all written by hand. And before the printing press and modern printing methods were developed, there really wasn't much of a concern about copyright. Once you wrote something down, that was it. But when the printing press was invented, the need for the dissemination of information became much easier. And that's when the need for copyright actually came about. And so the origins of copyright, unlike the origins of patent law, which goes back much further, trace themselves essentially to the time when the printing press was developed and the dissemination of written materials was made possible. And eventually, of course, people became concerned with more than just manuscripts reproduced on the Samuel Hopper's printing press. They became more concerned, and now copyright covers a wide range of works, as we've discussed: maps, performances, paintings, photographs, sound recordings, motion pictures, computer programs, and a million other things. But its origin has to do with the printing press and its invention. Today, national copyright laws have been standardized to some extent through international and regional agreements, such as, we talked about this last time, the Berne Convention and the European Copyright Directives. Although there are consistencies among nations' copyright laws, each jurisdiction has unique and separate, distinct laws and regulations that pertain to copyright. And there is a whole body of law in the United States that concerns copyright law. Congress was not vested by the Patent and Copyright Clause, however, with anything like the royal prerogatives that King James II had or King Henry had. Congress was restricted by Article 1, Section 8 very much. So the power that Congress has under the Constitution to grant intellectual property rights is nothing like what the kings of England had. It's much more restricted and I would say fair. under Article 1, Section 8, Congress's powers is limited with regard to subject matter and the purpose and duration of the contract of the property rights granted. The United States law has protected trademarks under now. Trademark is a different matter. The United States law has protected trademarks under state common law since colonial times, but it was not until 1870 that Congress got into the act. And Congress passed what's called the Federal Trademark Act. It's called the Statute of 1870, and it purported at that time to be an extension of Congress's powers under Article 1, Section 8. But remember, we talked about the Commerce Clause, which is Article 1, and Section 8. We talked about how it was called the Patent and the Patent and Copyright Clause. That's because in 1870, the Supreme Court struck down the statute passed by Congress to create trademark intellectual property rights. The United States Supreme Court said that the trademark law went beyond the powers that Congress had. They looked at Article 1, Section 8, and they said, we don't see anything here that grants Congress the power to grant trademarks. And it was a very conservative court at that time. And so in something called the Trademark Cases, the United States Supreme Court said, stop to Congress. You can grant patents, you can grant copyrights, but you can't grant trademarks. And there were some interesting cases. I think they had to do with champagne and whiskey. The trademark cases were a set of 3 cases consolidated for appeal to the United States Supreme Court. It was the Steffens, the Whitman, and the Johnson case. The first 2 cases dealt with counterfeiting marks associated with champagne, and the third dealt with the counterfeiting of a mark associated with whiskey. In 1881, after the trademark cases and after the United States Supreme Court told Congress that they could not grant trademark intellectual property rights via the Copyright and Patent Clause, they passed a new Trademark Act, but in the legislative history made it clear that it was being passed under Congress's power under the Commerce Clause, which is gives Congress the right to regulate commerce. Let me go back. Left click. It was not until 1905 that Congress would again enact a trademark law generally governing marks in the United States, though the 1905 Act was also carefully worded to fall within the Commerce Clause. And basically what the Commerce Clause is it's another clause in Article 1, Section 8, which talks about how Congress shall have the right to regulate commerce within the United States. And it's actually a broader power than Article 1, Section 8, the clause dealing with copyrights and patents. So Congress, after they were chastened by the United States Supreme Court, were determined still to grant trademark protection, and so they went back and made it clear to the Supreme Court that now they were acting under the Commerce Clause, which actually makes sense when you're talking about commercial brands like trademarks. In 1946, Congress passed the Lanham Act, which is part of the United States Code. That's what we're going to be getting into when we talk about copyrights, because the Lanham Act, Title 15, United States Code, Section 1051 to 1127, it's written down, you can go to the United States Code and read it, provides the entire basis for United States copyright law. And when I try copyright cases today and when I draft copyright complaints, that's the law that I cite. That's the law that gives intellectual property owners copyright rights in the United States. And it defines, trademark law as it relates to property rights. And the Lanham Act grants the United States Patent and Trademark Office with administrative authority over trademark law. So when it comes to trademark, the Lanham Act is the last word. I think I misspoke and I said copyright. The Lanham Act is the last word when it comes to trademark law, and it is all defined in the United States Code. Now, we were talking about the Commerce Clause. The Commerce Clause is a little different than the Patent and Copyright Clause. The Commerce Clause describes one of the powers enumerated in the United States Constitution that Congress will have. And it says specifically to regulate commerce with foreign nations and among the several states and with the Indian nations. These three clauses are all referred to separately. One is called the Foreign Commerce Clause. One is called the National Commerce Clause, and the other one is called the Indian Tribes Commerce Clause. So in legal documents and in scholarly discussions about the Commerce Clause, they actually break the Commerce Clause down into these three important clauses. And when it comes to trademark law here in the United States, the Lanham Act, which Congress passed, we're talking about the commerce among the several states. So you must have heard on television or must have heard somewhere people refer to the Commerce Clause. Well, that's the Commerce Clause that they're referring to. And it's actually broken down into those three areas. The one we're concerned with is the second clause, which is the fact that the regulating of commerce between the states by Congress. The limits of congressional power under the Commerce Clause is only the writings and discoveries of authors and inventors may be protected, and then only to the end of promoting science and the useful arts. And the concept of originality is central to copyright, and it is a constitutional requirement that Congress may not exceed. Generally, the purpose, as we discussed earlier, and as Ben Franklin and the other framers were concerned, the purpose of copyrights, the purpose of trademarks, and the purpose of patents is to promote creativity, innovation, and the spread of knowledge. And how we do that, and the tension that we have between that and the rights of commercial and intellectual property owners is the tension that we're always wrestling with in copyright, trademark, and patent law. And that's basically what I wanted to go through in terms of the history of these particular intellectual property rights. What we're going to do tomorrow is we're going to go into the differences between the three and discuss some examples before we really get in deep and start drafting our own patent application, our own application for a copyright, our own application for a trademark. Over the next couple of weeks, I'm going to be asking you to think of something that we can trademark and something that we can copyright and patent. So, any questions? Any questions? If there are no questions, then that means we have a few minutes for you to fill out the evaluations and over. So thanks. And finish your business.